If someone makes a profit selling his principal residence, that profit isn't taxed. But if someone has more than one home, which home is considered his principal residence? The court addressed this question in Guinan v. United States. Jean and James Guinan were retired. For a few years, the Guinans owned a Wisconsin home, where they lived during the summer, and a Georgia home where they lived during the winter. The Guinans then sold their Georgia home and purchased a winter home in Arizona. The Guinans continued to live in Wisconsin during the summer and lived in Arizona for the rest of the year. 2 years later, the Guinans sold their Wisconsin home and paid $45,000 of federal income tax on their gain from the sale. The Guinans later requested a refund of that payment, arguing that the gain wasn't taxable because the Wisconsin home had been their principal residence for at least 2 of the 5 years before the sale. The Internal Revenue Service, or IRS, declined to refund the payment, arguing that the Wisconsin home hadn't been the Guinans' principal residence. The Guinans sued the federal government to get the refund. The evidence showed that if the 5 years before the sale were considered individually, the Guinans had lived in their Wisconsin home for the majority of one of those years. When the Guinans owned their Georgia house, they'd held driver's licenses, voted, and paid state income taxes in Georgia. Similarly, after the Guinans switched their winter residence to Arizona, they got driver's licenses, voted, and paid state income taxes in Arizona. The Guinans hadn't held driver's licenses, voted, or paid state income taxes in Wisconsin. The Guinans had received mail and registered cars at all 3 homes and had held bank accounts in all 3 states. The Guinans had been involved in community activities in Georgia and Wisconsin. The Guinans' children didn't live in Georgia, Arizona, or Wisconsin. Both parties moved for summary judgment, and the court ruled on the motions.